The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
All right, thank you very much, Mr. Horn. Welcome everyone to the Court of Appeals in our virtual mode WebEx argument today. We have one case for argument today, which is Hailey v. Tropic Leisure. First, let me introduce the panel for the case. Judge Donna Stroud is head of the panel today. Our other judges on the panel are Judge Hampson and Judge Young. I usually say to my left or right where they're sitting, but they're on a grid here, so I'm not sure where they are. But anyway, welcome to everyone. And we have already gone through our sound check and everything, so we believe everything is working. But if anyone has a problem at any time and notices that they're not hearing or things are not working properly, just let us know. And Fred Wood, our wonderful IT person, will fix it for us like he does everything. So, all right. And if no one has any questions or anything, then before we begin, we will start with the appellant, Mr. Wade.
Thank you very much. Sorry, did somebody say something?
No, I think reminder to everyone to turn off your microphones if you're not speaking so we can avoid feedback.
All right, thank you very much. May it please the court, thank you all very much for having us here today to have this argument. I trust you all have read the briefs, and I think I've thought long and hard about what to say about this case, and I think the best way to start is just to be direct. And I think my brief lays this out in more detail, but my position is that the plaintiff simply has no case. There's no evidence and no law to support the case that they're bringing. And I think we'll probably get into a lot of different things today. It's been my experience with this case that usually happens. But at the end, I think we're going to continue to circle back to page 16 of the plaintiff's brief and pages 21 to 23 of my brief. And that is this, that you have to have something more than private action pursuant to a state statute. And there's just none here. There's no evidence from the Virgin Islands Small Claims Court showing that they themselves even knew that the system they were part of would violate Hailey's constitutional rights, as this court determined in the first appeal of this case. And then, and I will say nothing to indicate that this court would determine that for this state, because to my knowledge, as of right now, North Carolina is still the only court that's determined that any judgments from the U.S. Virgin Islands of the time period that we're talking about here are not entitled to full faith and credit. There's also no evidence in the record that there's any sort of understanding or meeting the minds at all between any of the defendants and the U.S. Virgin Islands court system. I think if you look at pages 10 to 13 of the plaintiff's brief, they've laid out, I think, what they consider to be the best facts showing that there could be some kind of agreement, tacit or explicit or otherwise, between the defendants and the Virgin Islands court system to deprive plaintiff of his constitutional rights, and it's just not there. Or, as I've maintained in the brief, I do think that there needs to be some sort of explicit or tacit agreement. But even if you want to take plaintiff's argument that there was some other kind of state action, there's not any of that there either, because Lugar, by its own terms, when it talks in this specific issue, and other cases that address Lugar, require that there has to be essentially the state and the private individual, when it comes to a 1983 claim, sort of sitting at the same table. We have nothing like that here. We don't have a magistrate making out the plaintiff's case. What we have is...
Well, Mr. Wade, if I can just jump in right there, because I think that kind of gets to the heart of the matter, and that is on this question, this exactly what is the standard under Lugar and prior cases? Where on one hand, it seems, on one hand, simply utilizing a court system is not enough, but it seems under Lugar saying it's something less than sort of an express conspiracy. I mean, one of the things Lugar says is the Court of Appeals erred in holding that in this context, quote, joint participation required something more than invoking the aid of state officials to take advantage of state-created attachment procedures. So that seems to indicate it's something less than a full-blown agreement or a full-blown conspiracy between a state and a private actor to give rise to one of these claims. So first of all, how would you articulate that standard within that kind of middle ground of legal?
Well, I guess here's what I would say is the reason that I've maintained that there has to be an agreement in this case is because Lugar isn't applicable to this case. Lugar, by its own terms, is only applicable to prejudgment attachments. And there's a big difference between filing a lawsuit, going and having a hearing in front of a fact finder compared to doing a prejudgment attachment on property. And that's why Lugar is that way. And in fact, just for a point of clarification, plaintiff raised in the brief, my point on this. And the only thing I want to do is make sure that I'm clear that the Supreme Court put that note in there in direct response to the dissent's concern that this standard in Lugar would be used for trials, for court processes where you have a judge. And that is exactly the reason they put that footnote in there. And that's why I've been harping on it and making sure to make the point that Lugar doesn't apply to this case. It's simply a different ball of wax. And that actually bleeds over into a lot of the other cases that the plaintiffs cited in their brief. What they want to do is try to shoehorn what was otherwise a full-blown, regardless of the outcome of Hailey 1. What we had here was in North Carolina, what this court and what our courts would consider is to be a flawed hearing, but it was nevertheless a full-blown hearing. There was a complaint filed, Mr. Hailey was served with it, and then there was a court date set, there was notice. And there's just a miles of difference between Lugar and those cases that address both prejudgment attachment, and the plaintiff also cited a case for post judgment collection efforts, and it's the same issue. And furthermore, and let me just tell you which case that is. I'll just take a minute to find it here. It's the Pennzoil versus Texaco case that's cited in plaintiff's brief. The interesting thing about that, and I understand the plaintiff's point on that, but even assuming that this court would consider that precedent applicable here, there's miles of difference between that. And furthermore, we don't have any allegation by the plaintiff that there was any issue with the post-collection judgment here. My clients brought the judgment to North Carolina, and then there was a constitutional process that took place. That process itself was not unconstitutional. It's not part of the allegations in this case that underlie the 1983 claim. So I hope I've answered your question. It was probably a little bit more long-winded than what you wanted, but.
Well, I guess maybe even taking Lugar specifically out of it, I'm just trying to figure out, what is the standard here? How do you articulate sort of, if there's a rule for us to apply here as to when, private action in conjunction with the state arises to this kind of 1983 claim, and how do we articulate the rule to apply, I guess? And that's, in light of sort of this panoply of case law that kind of hits all around it, where would you have us draw the line here?
To me, it's very clearly, the Dennis v. Sparks and that line of cases. Cases that directly address 1983 claims in the context of actions in the courtroom. And I wanted to take a moment to distinguish yet again from another case that plaintiff brought up in his brief with respect to the selection of jurors and whether that was state action or not. That was not a 1983 case. That's the Edmondson versus Leesville case. And I do want to take a minute to talk about that because I do think it highlights the difference between what plaintiff is trying to do and what we're contending is the law of this case. And the Edmondson versus Leesville case really focuses on whether excluding minorities from jury service is constitutional in civil cases. And in order to make the analysis and eventually conclude that it does, that the constitutional rights to make sure you're not excluded wrongfully for being a minority in a jury trial, civil jury trial. It talks about, and it does talk about Lugar as far as analyzing state action. But the interesting thing about that is when you look at that case and look at how the court applies Lugar and how much oversight and involvement the judge has in a preemptory challenge and how the court analyzes that in that opinion really highlights how much bearing the state has to have over the case or the issue or whatever it is, whether it's prejudgment during the trial or post-collection efforts. You have to have an unlawful activity that is basically the private actor acting the same as the government. And we don't have that here at all. If you look at Mr. Giardini's deposition testimony and his testimony at trial during the compensatory phase, it's very clear that he's using the court system, and the court system is consistently rebuffing what he is trying to do or achieve on behalf of Tropic Leisure and Megan's Point with respect to these collection cases. I think that as far as that, I don't know if the court has a lot more questions on that particular question. I could go through, I guess what I'll do is just mention briefly that if you look at the other cases that plaintiff has cited in their brief on this particular issue, such as Howerton versus Gabica, NCAA versus Tarkanian, the Snydatch case, North Georgia Finishing, Mitchell, the Tulsa case, all those cases either have the same distinctions or in many of those cases, they just don't address 1983 actions at all. Those appeals don't address the 1983 case. So that's why I would contend that the Sparks case and others that I've cited in my brief would control, and they would require some kind of agreement because you have the magistrate, which the Virgin Islands magistrate, being in an adversarial position or at least in a referee position to what my clients were doing in court, which was simply trying to collect on a contract that Mr. Hailey signed when he was down there.
So I think your colleagues on the other side would contend that it went beyond simply being a referee. And instead, essentially, they became the magistrates were coaches. The magistrates were coaching Mr. Giardini through the process impermissibly and allowing him to even practice in that court impermissibly, such that it went beyond the referee role. And so sort of moving to the next phase of it, I guess, in terms of summary judgment, I mean, I take your position is that summary judgment primarily should have been granted to your client on liability. So for purposes of summary judgment, though, that seems like there could be some factual tension there that could create a genuine issue of material fact as to how the magistrate's office here was operating and how your client or how your client's agent was operating. So why is that not a question of fact? And sort of follow-up question is, what other sort of factual tension points are there in this case, and how do we resolve those, either for purposes of summary judgment, or are there simply other genuine issues of fact that are out there?
I guess I'll say this. When I read Mr. Giardini's testimony, all of it, wherever it occurred, what I see is someone who's engaging the small claims court system no different than what I see on a regular basis. I'm in small claims court all the time doing evictions. This is just what it looks like, especially when you have someone who is not an attorney in there. if you read Mr. Giardini's testimony, it reads to me very clearly that he is trying to navigate the system. And he freely admitted, and plaintiff has cited this in the brief, that, when he first started, when Mr. Hailey's case was done, he was not very experienced. He did not know exactly what he was doing. And in those instances, sure, you would expect a magistrate to, set up the guardrails or the gutter alleys, if you're talking about a bowling analogy, whatever the case may be. They're going to do that. It's their court, and they're going to do what they have to do to make sure people stay within the bounds. But it also takes a party asserting their rights to make sure that that's done. And Mr. Hailey chose not to do so in this case. So what I would tell you is this: to me, when I read the evidence that was submitted for summary judgment, there is no genuine issue of material fact that my clients they simply did not violate Mr. Hailey's constitutional rights. There's no genuine issue of material fact showing that there's any sort of agreement, explicit, tacit, whatever, between Mr. Giardini or anyone else with my clients that they were somehow in agreement or a meeting of the minds with the small claims court system to deny people their constitutional rights. I don't know how else to say it. It's unfortunately one of those things where to prove a negative, you just got to go through and see if it's actually there or not. And what I'm saying and what I've been saying is it's not there. It wasn't there at summary judgment. It wasn't there at trial. Or at the very least, as we've argued alternative in our brief. At the very, very bottom line is that there would have been a genuine issue, at least to be determined factually, whether there was an agreement or not. And so on both those grounds, we would suggest that partial summary judgment was improper. But I want to stress now, as I did in my brief, that this case to me has been based on facts that don't support the law that's required to make out a 1983 case at all. And that's why we've asked for and strongly argued for relief here in this court. I'll spend as much time on that because I do think that is the crux of the case for me. I mean, I will stress again that the summary judgment in this case was, obviously it really shoehorned us into what kind of issues we could present to the jury. And we believe that that has properly been presented to this court to be overturned and in fact rendered in our favor. But if that's not the case, then we believe all the other issues are also preserved. I do want to take a minute and talk about, if there's no further questions on that, the attorney's fees award in this case and whether the compensatory and punitive damage claims were actually separate. I've actually provided the law in my brief that would support that, and plaintiff has provided a lot of the contrary. I do think this is somewhat discretionary. What I would argue is that if you look at the facts of this case, you can clearly make out how distinct and different these claims were. And quite frankly, when you look at a punitive damages claim, you do have separate elements. I mean, completely separate elements. We had separate jury charges, separate everything. Those are two completely different claims. And if you look at the evidence in this case, which I apologize again to the court how voluminous it is, but when you look at it and look and see how much time in the attorney's fees affidavit for plaintiff's attorneys, how much time they spent with those materials, you can see that a vast majority of the time was spent trying to make this punitive damage claim, and it simply wasn't successful. I think the trial court erred substantially on that, and now on something where they failed on more than half their case, because I think most of the evidence was they were gathering was put toward the punitive damages portion. But I think that the trial court erred not giving us at least some relief, at least reducing the award or awarding fees to our client, which I've also set out the law that would support that also.
So in terms of that sort of alternative relief of reducing the amount of fees awarded versus the legal basis for the award of fees, I mean, is that discretionary on the part of the trial court to determine the amount that's reasonable?
Yeah.
Thank you.
Yes, and there's guardrails on that also, and there's an analysis that goes through. But at the end of the day, yes, I'm not going to pretend that it's otherwise. All right. Finally, you know, if you haven't reviewed the attorney's fees affidavits for the plaintiff's counsel in this case, I'd encourage you to do so. I mean, when you look at it line item by line item and look at how much time was spent on certain things, I mean, the only thing I could say is the same thing that I put in my affidavit and reiterate what Randy James put in his affidavit. Opposing the attorney fees award, and that is simply that there's just too much time spent on things that didn't need to be spent that much time on. I don't know how else to phrase it, but I think people who've been in private practice have a pretty good idea of what is reasonable and what is not. And I think the trial court failed to look at that carefully in this particular instance. As far as my notes and things that I have prepared to talk about, I was expecting a little bit more interruption, but I'm happy to entertain other questions or reserve the remainder.
Okay, if there are no other questions right now, then I don't believe, yeah, okay. Then we will move on to the appellee, Mr. Armstrong.
Thank you, Your Honor. Can everyone hear me? Okay. Again, my name is Lamar Armstrong III. I'm here on behalf of the plaintiff appellee, in this case, Jerry Hailey, or sometimes referenced him as Mr. Hailey. Unless I always want to address any questions that the panel may have, first and foremost, not knowing what questions you may have. But if there are no burning questions, I'll jump straight to Judge Hampson's question about the standard. What is the applicable standard? And Your Honor, I think you hit the nail on the head, which is that is the key issue. What standard do we apply as it relates to color of law in this case? And the starting point is Lugar, because Lugar does announce this two-part rule, and this is why I spent as much time as I did in my brief explaining at the beginning of my argument section, here's the standard, here's the different tests that are applied and how you apply the standard, those sorts of things. But admittedly, Section 1983 is a pretty open-ended, vague statute. It doesn't give you a whole lot of guidance to figure out what, or really any at all, what is action taken under color of law, what does that mean? So Lugar goes a little bit further and explains, well, what it means is when you have a private party whose actions are, quote, fairly attributable to the state. All right, so it's fair attribution, which begs the question, what does that mean? Because that's still sort of a vague standard. And so courts across the country have wrestled with that question. And various tests have sort of come out of that, including several more U.S. Supreme Court cases to define what fair attribution means. And one of those several tests that is announced is, and the one I think that Lugar explores, is the joint action test. Sometimes courts will also call it the joint participation test. And so, and so again, I go through the standards and the language, but the bottom line really is that there is no black and white hardline rule. Here's what constitutes color of law, here's what doesn't in a private actor context, even when it relates to a private actor engaging in the judicial system, which is what we have here. Rather, the Supreme Court has been very clear and has repeated this several times, including in multiple cases that I've cited in my brief, that what is and what isn't depends upon the circumstances and the specific facts of each case. And so the bottom line is what's enough, what is sufficient depends upon the facts of each case. So, but one of the tests sort of within this joint action analysis that I think is helpful and the shoe seems to fit in this situation is I cited this in my brief, the NCAA versus Tarkanian opinion, which is on page 19 of my brief. And that case says that you can have color of law, action under color of law, if a state official grants a special mantle of authority for a private party that gives that private party special access or special tools that nobody in the general public has. And that by granting that special mantle of authority, the private party uses the sort of the special mantle, the special access to violate someone's constitutional rights. And that's exactly what we have here. We have the USVI Small Claims Court magistrates and officials creating this special mantle of authority for the defendants, in particular John Giardini, to be able to walk into their courts, not just in an isolated sense, but over and over and over again. Mr. Giardini, by his own admission and testimony, was that he appeared in these small claims proceedings 50 to 75 times in about a 2-year period, from summer 2013 through summer 2015. So 50 to 75 times in 2 years, he's allowed to walk in, not just walk into court, not just file complaints, but to go in there, to raise arguments, to speak in court, when by their own rules, he shouldn't have even been allowed to speak, much less go above and beyond that to obtain the default judgments and even the way they went about obtaining the judgments. For example, yes, sir.
If I can just ask my light this one out too, but so, you know, what we seem to be hearing are two very different versions of the events that are occurring in the U.S. Virgin Islands, and I asked Mr. Wade about this as well. You know, and when you say these cases are very fact specific, all of that seems to suggest that perhaps summary judgment may not be the best vehicle in these cases. So I'm with that. How is there not a question of fact on that, and what other factual tension points do you see in this case that you think obviously were resolved in your favor, and how do you resolve those genuine issues with that?
Sure. So the first thing is that even in the case that the defense cites in their brief, color of law could be present issues of facts if the facts are disputed. What makes this different is there aren't any facts, at least none that are material, where the parties actually dispute what happened. All right. And so there's a distinction here to be made. It's not that there's a dispute that Giardini showed up in court, that he said whatever he testified he said, that the default judgment was entered. Here's a copy of it. There's no disputes like we would have in a traditional who ran a red light, who had the green light scenario. So the facts aren't disputed. Rather, what's disputed is the meaning of those facts. And the meaning of the facts is where we have summary judgment, and why summary judgment is, generally speaking, proper for the color of law issue, at least in a scenario like this where you don't have facts that are disputed. And as Mr. White has said several times in his brief, you know, look at the transcript, read the transcript, see what it has to say. All right. None of the facts that were admissible, relevant on summary judgment, and again at trial, came from my client, other than very limited set of facts of what happened when he got off the cruise ship and went up and bought this timeshare back in 2001. That was just sort of background. None of that really matters in terms of color of law analysis. Every single fact that speaks to the color of law analysis came directly from the defendants and only the defendants. So the point is, Mr. Hailey wasn't down there when any of this happened. He can't testify and didn't testify. Well, no, that's not the way that these interactions happen between the defendants and the small claims judges, because he wasn't there. That's the whole point. That's why we're here. He wasn't allowed to have an attorney to show up and find out what happened and to defend his rights. So all of the facts are what they are what Giardini and Mr. Shelby and the defendants have testified to. and they come directly from their files. All right, so it's a long-winded way of saying we've got the facts, we don't dispute what's in black and white on the piece of paper, rather we dispute the legal significance of those facts, of that evidence. The other thing that I would say to answer your summary judgment question is that both parties stipulated, and this is in my brief, and I've got citations in my brief, but both parties stipulated that there was no issue of fact, that in fact, summary judgment as a matter of law is proper. And both parties put that in front of the trial judge and said, Judge, this is an issue of law to decide on summary judgment. Color of law is an issue of law. In fact, the defense said that everything is an issue of law for summary judgment. Our motion for summary judgment was just on the color of law issue. So we said, so everybody agreed, color of law is an issue of law that's properly dealt with and resolved on summary judgment. And nobody, not us, not the defense, argued that there was an issue of fact on color of law that meant that we needed to have that issue tried. So my point with that is we all know that the law is that you cannot, at the trial level, you cannot invite error and then complain of that error on appeal. So if the defense, as they did, invited and in fact encouraged the trial judge to resolve the issue on summary judgment as a matter of law, they can't now complain about, well, no, it was an issue of fact, because that's not how they addressed it at the trial level. And that's really just a different way of saying the same thing as to why they now shouldn't get a new trial, because they didn't ask for a new trial.
Well, if the trial court, had the trial court discerned a genuine issue of material fact, the trial court could have denied motions both ways and proceeded to trial. That didn't bind the trial court's ruling on summary judgment, that it had to rule one way or the other. Is that correct?
I think that is correct, but that's not what the trial judge did. So now we deal with what the trial judge did. And I think that both parties are now bound by that because we invited the trial judge to do what he did. So, and then I'm sorry, Judge Hampson, you had a follow-up question to the summary judgment one. Okay.
Well, I think you've already answered it. I was just trying to ascertain here, where are sort of the key factual tension points in this case, and your answer seems to indicate there are really no, from either party standpoint, and obviously Mr. Waite can speak to this again too, but the facts are effectively agreed to.
Yeah. Now, look, Mr. Waite has, in briefing, taken issue with our summary of some of the testimony, but he's provided the citation. So have I, and we both have encouraged the panel to go just read the testimony. It is what it is. I've triple and quadruple checked it, and I think our summary accurately reflects what was said. He disagrees, but the transcript is what it is. The other thing I'll say is, in response to your Honor's question about the summary judgment issue, I just heard Mr. Waite argue that there were no facts on summary judgment that could have proven that there was an actual agreement or conspiracy, and therefore they were entitled to summary judgment on that basis. But that goes back to your Honor's original question, which is, what's the standard that we apply in this case? And so if you don't mind, I'm going to circle back to that just for a minute, because the defense seems to be staking out the position that we have to prove a conspiracy. If we don't prove an active conspiracy, meaning an intentional meeting of the minds or an active intentional agreement between private actors and small claims court, that we're out. We can't support a 1983 claim. And so that's why I spent a lot of time in my brief exploring that and showing that that's just not true. What the defense has done is a couple of things, and it's really circular reasoning and logic what they've done. But one thing they've done is they've cited to the cases like the Dennis versus Sparks case and like the Adike, if I'm pronouncing that right, Supreme Court case, and saying, aha, in these cases, they were analyzing a conspiracy, and therefore it must be that you got to have a conspiracy in every 1983 case. Well, if you read those cases closely and carefully, none of them say that the floor is conspiracy. That if you don't prove something other than intentional conspiracy, you're out on 1983. And in fact, that would be contrary to the statute. The statute doesn't say anything about intent. This is not an intentional tort. This is not strict liability, as Mr. White has suggested in his reply brief. So if it's not conspiracy, what is it? And again, if you look at Lugar, it's much less than conspiracy, and it's much less than meeting of the minds. And that's why I was getting into this idea of a mantle of authority. And a mantle of authority is we, the state, are going to give special access, almost like backroom access to one private party that we're not giving to anybody else. So we're effectively allowing, by our actions, by our joint participation, we are giving a private party sort of an end around of the law. You know, we're going to allow you to go around the law and not have to comply with the law, unlike everybody else. And by giving that special access, they're jointly participating. There's joint action because they're creating the mantle of authority, and they're enabling and equipping the private party to step on that special mantle of authority and use it to deprive someone, my client, of his constitutional right to due process. So I think that is the framework that we're looking at here. And I would give an analogy to that. And this analogy comes from the Howerton versus Gabica case that I cite in my brief, page 18 of my brief. And so the analogy is, suppose, for example, I know someone, I'm a landlord, okay? And Mr. White says he's in small claims court all the time, so there's a lot of landlord-tenant stuff in small claims court. So I'm a landlord, and I just happen to know a sheriff deputy here in Johnson County. And I call him up and I say, you know, Mr. Deputy, I have a tenant who's not paying rent. I need to get him out. I need to evict him. Can you go over there and knock on the door and tell him he's got to go? Well, obviously that would be improper for me to ask that and improper for the deputy to do that. But suppose he says yes, and he goes out there, knocks on the door, you know, takes the guy by his collar and throws him out. Okay, well, what's happening there? What's happening there is there's joint participation between a private party, me as the landlord, and the state actor, the deputy, who's sort of helping with the process of the eviction, and doing so in a way that avoids the correct legal process, the process of summary ejectment that everybody's got to go through to get an ejectment of a tenant for not paying rent or whatever. And so notice what's not present, and that was sort of it's similar to the fact pattern in the Howerton case where a landlord is performing a self-help illegal eviction, kicking a tenant out, and there's a police officer that's basically standing there condoning and allowing it to happen. All right, and in that case, they're saying that is joint action, joint participation. But notice what's not there in my hypothetical, or in that case, what's not there is a specific agreement. You know, I didn't, in my case, in my situation, I didn't specifically say to the officer, you know, Mr. Deputy, let's put all this in writing. Let's make an agreement, or why, even just a handshake. Let's agree that you and I are going to do this, and the purpose for us doing this is to violate the tenant's constitutional rights. All right, the right to be heard in court, the right to petition, to defend against whatever action I as landlord would file, the right to appear by an attorney, whatever. We didn't have a specific agreement in place to do that, right? There wasn't a specific intent, but nonetheless, there was joint action, there was joint participation, because we were both active participants in this illegal eviction. Same sort of thing here. The facts are, it's a different scenario, but it's the same basic situation where you have a private party that combines in joint participation with a state actor to violate someone's right to an attorney in court. And let me just say that, and I know that the defense has cited these cases saying that, you know, if all you do as a private litigant is file a lawsuit or appear in court, that is not enough to come up with state action. But that's not all we've done. Our 14 or 15 pages of facts in our brief, there's a reason why we put all that in there, because there's a lot there that go above and beyond merely, gee, I'm an innocent private citizen, I'm not a lawyer, I don't know what I'm doing, but I'm genuinely trying to enforce my rights or the defendant's rights, and by gosh, I got it wrong. I'm sorry, I didn't know any better.
And so one thing I suspect we might hear from Mr. Wade on rebuttal is that even in that hypothetical, even if there's not an express agreement, there is some tacit agreement between you and the sheriff and the sheriff's deputy in that case. So we accept Mr. Wade's standard that there has to be some tacit, at a minimum, some tacit agreement. What evidence is there of a tacit agreement between Mr. Giardini and the defendants and the OFBI magistrate's office?
So in this, I'm sorry, Your Honor. I didn't mean, okay. So there is actually, in this case, let me find a specific site for you. Mr. Giardini, in his own words, said that he reached an agreement with magistrates, small claims magistrates, to provide rental credits to judgment debtors. And he describes that as when the resort would rent out people's units. For example, my client, Mr. Hailey's unit, they rented it out. Well, whatever money they got in that rental was, by this agreement with the magistrate, supposed to be offset against Mr. Hailey's judgment. All right. And so he actually, and this is in a deposition transcript that was before the court on summary judgment, and it was again admitted as an exhibit at trial. His words, we didn't feed him that word. He said, we reached an agreement, a word, with the magistrates to provide these rental credits. And if you read between the lines, and this is a matter of argument, okay, this is where he didn't expressly say this, but if you read the testimony, it's pretty clear that what they agreed to was, look, we'll give you these default judgments, but in exchange for doing this and following along with this and giving you all these default judgments, you need to be giving these people the proper offsets that we think they're entitled to. All right. And that's improper. The reason that's improper is the magistrate's not just dealing with the facts and the issue in front of him in the proceeding. What he's doing is he's saying, it's kind of quid pro quo. He's saying, I will give you this. I will, in future cases, give you these default judgments if in exchange you provide these rental credits. And so there is even if we have to prove some sort of explicit agreement, right there is an agreement in place by his own words that's improper. And the reason it's improper is because the judge is forecasting and saying, here's how I'm going to do this, and here's how I'm going to rule these other small claims default judgments that you've got in the hopper. And so I'm going to continue to go along with this if you agree, if you promise me that you're going to give these offsets, these credits. Now, the main point of that is we can get into a debate as to whether or not that's proper, but even if it's proper, the main point for the purpose of appeal here is all that was done without Mr. Hailey being given a meaningful opportunity to be heard on that, right? So this conversation, this agreement's being had, and Mr. Hailey, he's forced into a decision to either not show up at all because he can't have a lawyer. He's flying down there on his own, spending his own money, a lot of money. And he's already received these letters from Mr. Giardini on behalf of the defendant saying, don't bother. You're going to spend all this money, but you're going to lose. You're not entitled to a lawyer. The system is stacked heavily against you. I've not lost a single one of these cases. All these things are things that Giardini is saying in his abrasive collection letters to my client around the time that he's getting this default judgment. All right. So the point there is, even with this heightened standard, there is evidence that can be inferred under the circumstances that there was some sort of at least tacit understanding, if not express in writing agreement. And the other thing, Your Honor, that I'll point out about that is all of this was argued to the jury. All right. We had the summary judgment and the judge ruled the way he did, but that did not stop the defendants from going there at trial. And so they regurgitated all this evidence and the same arguments that they would made on summary judgment under the umbrella of whether or not that what Giardini and the defendants were doing was reasonably foreseeable, whether or not there could be, as a matter of law, proximate cause or intervening cause. So they argued the same stuff to the jury anyway, and it's clear the jury didn't buy it. And the jury, it was under the proximate cause instruction, but the jury said, no, I mean, it's obvious to us that they knew what they were doing. that they knew that they were leveraging a system intentionally with the magistrates to violate Mr. Hailey's rights, and that scenario, it was reasonably foreseeable that Mr. Hailey would be damage proximately caused as a result of what they were doing. That is something that the jury spoke to, and believe me, was, and you can see in the transcript, was well argued to the trial court and to the jury. Questions before I keep going? For anybody? Okay. So limited time left. Another really important fact in all of this is that, again, going back to creating this mantle of authority, is that Giardini was granted this special access because he never should have been allowed to speak in the first place. He was not, under any definition, a personal representative of the defendants. Now, Giardini, the defendant's response to that is, well, he was an employee of the defendants, but we're not bound by his explanation of that, because there's lots of evidence to the contrary. And I've pointed out some of this in our brief, but the defendants never treated him as an employee. They always treated him as an independent contractor, debt collector. He was called a collections manager. He was never issued a W-2. In fact, when the power of attorneys that were issued, they called him an attorney in fact. They never said he was an employee. When he signed the complaint against my client, he signed it as, quote, plaintiff's representative, even though under the no attorney rule, he had no authority, no basis to sign on behalf of the defendants. The defendants were supposed to still sign themselves. And so because of all of this, the reality is, the bottom line is, he went into small claims court over and over and over again, engaging in the unauthorized practice of law. And that's a big deal. That's not a minor technicality that lawyer Armstrong and the plaintiff's now trying to get a lot of traction of after the fact. That's a huge deal. I mean, unauthorized practice of law is a criminal offense, at least here in North Carolina it is. And that's why we, as a self-governing organization, the practice of law, we govern ourselves to make sure that our attorneys, our legal professionals are acting within the bounds of what's correct, not just to protect citizens and residents of North Carolina, but to make sure that our lawyers don't go into other states and territories and do things that they can't do here either. And so that is a big deal. And that is, in essence, what the small claims court down there enabled and equipped the defendants to do, is to practice law without a license, to engage in unfair debt collection practices, and at the same time claim that, oh, no, we're not a debt collector, we're just a personal representative or an employee. Moving on, I get just 4 minutes left, 2 minutes left. The attorney fee issue, I'll speak to that for a minute. For one, before I do that, any questions? I'd rather answer questions in my limited time if there's any questions. Okay, so for one, I would encourage the court to look at the affidavits that we put into place, as well as the court's attorney fee award. They're all very, very specific findings, and it is discretionary since those findings are in place as to both the level of the award and as to whether there should be any reductions to the award. I'm sorry, did I? Okay. So the other thing about the punitive damages being a separate issue, well, except for the fact that the defendants, and this is in the record somewhere, they did not move to bifurcate punitive damages at trial until like the Monday of trial, and we're talking about the pretrial order. All right. So until we as plaintiffs show up for trial, we're preparing as if punitive damages and compensatory damages are all going to be tried together. All right. So all the prep work that goes into trial, had they announced their intentions to bifurcate trial earlier, maybe some of that time could have been saved. So it's tough for them to complain about that now. Secondly, I would look at the transcript. The trial court really, really wrestled with the scope on the compensatory phase of trial. There were lots of objections, lots of arguments about whether certain pieces of evidence, certain testimony should be admissible on the compensatory phase of trial or only are admissible on the punitive phase of trial. And the reason for that is that it's all interconnected. It's all interconnected. And the reason it's all interconnected is if the defendants saw an opportunity with this no attorney rule and leveraged it to their benefit, then obviously what they did with my client was not an isolated situation. All right. The defense wants the court to adopt this story that, well, just an innocent citizen didn't know any better, isolated event, when the reality is that they filed 695 small claims complaints, 500 of which occurred again within that 2-year period. They collected approximately $1.4 million from these small claims complaints until the government down there shut them down from doing it, at least for the time being, the stay order that's in the record. So the point there is, this didn't happen in isolation. This did not happen to my client in a vacuum. They developed a very specific scheme and plan to do this to lots of U.S. citizens, lots of foreigners, including my client. And therefore, how they went about doing that with others is relevant to how they went about doing that with my client. It all fits into the same scheme, the same intentional, whether you want to call it conspiracy or not, the same intentional plan, what I call verbal agreement in our brief, to leverage the no attorney rule and to do it in a way that deprived someone of their constitutional right to an attorney. They knew, regardless of whether or not they were constitutional law scholars, okay, and knew that by what they were doing, they could be violating due process rights. They knew that they were depriving someone of their day in court with an attorney. And the evidence makes that abundantly clear. They knew that. In fact, anytime the defense and Mr. Giardini in particular were challenged, his response in my client's case and others is no lawyer in small claims court. So he very much knew what he was doing. I see that my time is up, and thank you, Your Honors, for your consideration.
All right, thank you. All right, Mr. White. You've got 30 seconds.
I think I'll just start with, where Mr. Armstrong left off there. And I think he really finally sort of articulated what the problem with the plaintiff's case is. They believe that because my client used this system and because an attorney wasn't allowed, that can support a 1983 claim. And it's just not the case.
Well, Mr. White, is mine? Yeah, I'm on, right? Okay. Let me ask about the fact of Mr. Giardini not being authorized to actually do this process and being allowed to do that. What's your response to that?
I've gone through that in my brief pretty extensively. And plaintiffs have continued to say this over and over. But the bottom line is this. Mr. Giardini was pretty clear in his testimony that he was allowed to do this. There's absolutely no evidence whatsoever to show that he doesn't. I mean, there's just...
Well, I understand obviously he was allowed to do it. I guess what I'm asking about is apparently he is supposed to have some sort of documentation as personal representative or whatever to do it in that court system, and he did not have that.
I'd have to look. I've cited the U.S. Virgin Islands law on this. Businesses are permitted to have a representative.
Right.
And I do not recall if the rule requires some sort of writing to that effect or not. There is a case called, I believe, Gilron, and that case sort of it's not I will warn you ahead of time, it's not a very good case for sort of parsing out what's permissible and what's not, but it does support that what Mr. Giardini was doing was permissible. I don't know how else to put it, and not improper.
I guess what I'm asking is, obviously he's allowed to do it, but but from what I've seen, and I haven't read the whole thing yet, but from what I've seen, there's was supposed to be some sort of authorization or document, something for him to be able to do this, even if he wasn't licensed as an attorney. There was sort of an intermediate status, I guess, that they would allow someone to represent a company in their court that he was apparently lacking for a substantial period of time.
My contention is that he wasn't lacking anything, that he had checked the boxes he needed to check in order to be able to do what he was doing. There's, as far as unauthorized practice of law, there's no evidence of that at all. That's been something plaintiffs have contended up here, but there's no evidence of it besides, plaintiffs claiming that that's the case. It's not a conclusion you would reach from the evidence looking at the actual evidence.
So, Mr. Wade, if I could follow up on that, please. So is it your understanding that if someone went into court under these circumstances and represented to the court, they had the authority to be there on the business's behalf, that would be sufficient?
Listen, I don't have the Virgin Islands rule in front of me, and I don't want to misstate it. So it really depends on what the rule says. And I apologize about that. I just don't want to misstate the rule, but it was a power of attorney, and it is in the record, but otherwise the Gilron case and the other, and Mr. Giardini's status as an employee, which what Tropic Leisure or any of the other defendants, how they decided to address his employment status or whether they complied with IRS rules and things of that nature are simply not relevant, because this really gets back to what does the evidence show? And the evidence really only shows that Mr. Giardini was an employee. And because of his status in that, and because he did have what Virgin Islands law required him to have, the status anyway, to have, he was able to proceed. And I think that's actually supported by another thing that Mr. Armstrong just argued, and that was this credit for the rental units. The really interesting about that to me is that first of all, I would take issue again with the characterization that it's actually an agreement. If you look at Mr. Giardini's testimony, I'm not familiar with the exact page of that, but I feel confident if you look at the context of the entire thing, it's not an agreement per se. It was more an understanding between him and the magistrates that if he was going to bring these kinds of claims, he had to give that credit. They were going to require that if it came up. They may have even asked it even if the defendant was not there. But the really interesting thing about that, even assuming that it's an agreement, which we would contend against that, but even assuming that, as Mr. Armstrong argued, it benefited the defendant, someone who probably wasn't even there. And I just don't understand how you can argue that there's a quid pro quo between the court and the defendants with something that's benefiting someone who may or may not be there at all. I mean, that example, I think, really highlights how I get that the plaintiffs don't like the U.S. Virgin Islands small claims court system at the time that Hailey's case came forward. I understand that. But to make the jump from that to a joint action to violate constitutional rights is so massive. And I would contend again, the evidence is not there to show it. Just using the court system is not 1983. There has to be joint action. And that brings me actually back to Judge Hampson's questions regarding what's the standard. I don't think the standard is I will say this, to get to it does take some peeling back of the onion layers, and I will admit that fully. But the interesting thing is the Adicus case that I talk about in my brief, that is relied on by Lugar. And the Adicus case is the one where this mutual understanding, the meeting of the minds, all that comes from. And so you have to understand that Lugar was in fact in harmony with Adicus, and really, and there's no conflict there. And maybe that's why it's hard to explain, why there's these different levels of whether there's a different standard to Lugar. It's just not. There has to be something. And I think what Lugar does is say, in this particular instance, when we talk about prejudgment attachment, then the requirements that we outline at Adicus are going to be satisfied. And that's what the court actually says in that opinion. I think it's page 941 of that opinion. They talk about Adicus. So to me, I guess I don't really see I don't really see how there's any real conflict there between the standards. There has to be a meeting of the minds in some context somehow for something. On the NCAA versus Tarkanian case, that's a really interesting case. And actually, I think if I would have thought about it, I probably would have cited it in my brief to actually support my case, because, in that case, the Supreme Court found that the NCAA was not acting under color of law. So to the extent that there's black letter law in there, the plaintiffs would contend supports them. I would contend that the actual outcome does not. I think that, again, it just gets back to this question of whether the state, and going to the Howerton example that plaintiff used, is whether the state and the party are sitting at the same table, whether they're moving in the same direction. And what I would say, again, is that the evidence clearly showed that it was adversarial between the small claims court and Mr. Giardini and the defendants. I think that, to me, the extent of the suits, I've addressed this a little bit in my reply brief, but and I won't go into any details on it. But we're not talking about a big hotel here. We're not talking about a hotel that's a chain. You're talking about a privately owned hotel with a lot of delinquent accounts that had already been through bankruptcy once. They had a lot of members who weren't paying. So to the extent that these numbers show, I would just say the numbers don't show anything. The amount of lawsuits don't show anything. And as Mr. Armstrong just said, this is not an unfair debt collection case. It's just not. I think that, Mr. Armstrong also mentioned these collection letters and kind of the language in them. And, I've addressed that also a little bit. But the interesting thing is, one of the crucial facts to me is there's no evidence that the contract that Mr. Hailey signed was signed under duress or under any inappropriate circumstances or anything like that. He signed up for what he signed up for, and he agreed to this contract. And I think that that's part of the reason why you see Mr. Giardini having confidence about bringing these cases. He's got a contract. And I'll be honest, the contract is fairly simple and straightforward. It's not complicated. I mean, to the extent that Mr. Giardini was successful in these, I guess I would expect that. Even if defendants did come to the court, I would expect that, whether he's pro se or not. I mean, when it's a fairly simple contract issue, then that's the outcome that you would get, much like landlord-tenant. If you haven't paid rent, then you're probably very likely going to be evicted if it's brought in a small claims court. As to the facts that plaintiffs have raised, both now and in their brief, there's, as I think it was Judge Hampson that actually mentioned the fact that virtually none of these facts have any mention of the court at all. I mean, there's just nothing to show joint action, which they're at a minimum under Lugar or anybody else, there must be joint action. And I apologize, my timer just went out. Thank you very much for having me here today. I really appreciate it. I guess if Judge Straub permitting questions after time, then I'll take it.
Anybody? Yes. Okay, we've still got, or did it go? No, it's going up. Yeah. Okay. Let's see. Any other questions about the panel? Okay. All right. Well, thank y'all very much for your arguments. We made it through without any major technological problems. So thank you very much.
Thank you, Your Honors.
Thank you.
The session of the North Carolina Court of Appeals is now adjourned.